Well, good morning, everybody. A bit early for a lot of people to be tuning in. I quite appreciate that. Hopefully you'll get a chance to catch up with this video later on today or tomorrow at some point. I do apologize, it's taken a couple of days to get around to doing this part 2. As some of you might have noticed, I have been preoccupied with ornithology. That was purely a project for my wife, who wanted a couple of videos that she can use at the nursery to entertain the kids. So if you were entertained also by the videos of the birds feeding in our garden, then that's great. But I had to carry down to the demands of she who must be obeyed, obviously. And also I wanted to do a couple of recordings of some well-known two-steps, of which obviously Liberty Bell is a very well-known two-step. There's been some interesting videos put out on YouTube over the last few days. Obviously there was Eric Ose talking about the Scott Davis case, and incidentally, one bit of good news, I have searched everywhere and eventually I've managed to find his bottle of Black Label, so that will be taking a bit of a hit later on, just to prove that it is Black Label. That's it, Johnny Walker Black Label. So I will be enjoying some of the dude's whiskey very shortly. Not just yet, of course, because it's only 10 to 10 in the morning. So even for a mad Scotsman, 10 to 10 in the morning is a little early. Not unknown, but a little bit early. Yes, of the videos that I saw, then later on in the evening, there was obviously Linda Kay, or was that before the dude? I lose track. And then the new Tracy Strunsey channel of the Scales of Injustice. I've got that right. Where we had Ricky Kidd on talking about his exoneration and his appeal to try and get really Lamar Johnson released, and also the lawyer for his lawyer was on, and that was very good. And then just this morning, I missed it last night because it was the early hours of the morning here in Scotland. An interesting chat with Silkman and Millbilly, Kelly, and a few other people, like somebody called COVID. What was the name? It was like a pun on two interesting recent developments. And Kat, I think. I do apologise. There was about 5 of them in the group chat talking about the RAV4. How many RAV4s are there? Like I've said many a time, I think it's a case of we cannot sort of poo-poo different people's theories. Whatever theory comes up, I've never yet seen one logical theory that ever points towards Stephen Avery and Brendan Dassey. Every other theory points well away from them and points towards law enforcement corruption. So anyway, some interesting videos to catch up with. Apparently this weekend, Sunday, it's Mother's Day over in America. We've already had Mother's Day here in the UK. You obviously have it on a different day to us. So Rob Bellin hopefully will be catching up with us the following weekend to talk a little bit more about things like prosecutorial immunity, wrongful convictions, false confessions, and stuff like that, which we have engaged him in discussing over the past month or so. Also, I believe Fleetside is busy putting together his next presentation, which obviously to micturate on one another's rug when it comes to ideas and thoughts and opinions about the case, because as I say, I've never yet come across anything that would ever point towards Stephen's and Brendan's involvement. So anyway, carrying on then with, and we didn't get that far through this opinion, so there might even be a third part to this one, you'll be pleased to know. So for anybody suffering from insomnia, these are definitely the ones to listen to. Okay, so I'm going to do this and this and this, and hopefully everything will be working correctly, but I will just take a moment just to check and make sure, because I always find it it's a good idea to make sure that everything is as it should be. And I will just enlarge slightly the text. No, gone too far. Back a step. Yeah, there we go. There we go. Okay then. Oh, so as I say, where we stopped off was at the beginning of this third part of somebody help me understand this. Problems with the court approaching, with the court's approach in Connick. Remember, this is Harry Connick Sr. So one wonders, in fact, Hugh pointed out that Hugh Fraser, that apparently Harry Connick Jr. comes from the same area as this Harry Connick Sr. Anyway, let's, after reviewing both the prosecutorial immunity and municipal liability precedent, the Supreme Court concluded in Connick that a district attorney's office could not be held liable under Statute 1983 for a Brady violation by one of its assistant district attorneys. There are numerous problems with how the court arrived at this rule. First, the functional approach has proven weak as a mechanism for determining when prosecutors should be given qualified rather than absolute immunity. And that's certainly one thing that I will be delving into with Rob Bellin, to have a look in a little bit more detail, hopefully, at the differences between a qualified immunity and absolute immunity. Okay, second, the court's decisions have yet to satisfactorily answer what a pattern of constitutional violations given rise to liability would look like. As I say, this is 2012. This is before we got to see exactly what Ken Kratz was up to. I suspect the author of this would now realise exactly what a pattern of constitutional violations look like. Third, I'll just give Kathleen Zellner a buzz. Third, the court's alleged common law foundation for prosecutorial immunity is tenuous at best. Ultimately, poorly reasoned decisions have granted prosecutors and their municipalities de facto absolute immunity for their actions. Oh, I knew I shouldn't have done that. Now I've completely lost where I was. I was at the beginning of page 1339. There we go. Found it again. Oh, just in time. The failings of the functional test. The Supreme Court's functional test for determining what type of immunity applies to a prosecutor has been plagued with problems since Imbler versus Patchman. As the court applies the test to different factual scenarios, its failings are readily clear. The federal circuits are specifically struggling with the implications of the functional test in situations where prosecutors not only hide exculpatory evidence, but also actively falsify evidence. Falsification of evidence would likely take place during the investigatory phase of a prosecution, when the prosecutor is only protected by qualified immunity. However, the false evidence cannot actually be used in violation of a defendant's constitutional rights until trial, when the prosecutor is protected by absolute immunity. When the functional divide is taken to its logical extent, it means that prosecutors are protected by absolute immunity for falsifying evidence. Practical problems with the functional test. The functional test for determining reliability has been criticized since the days of Imler. The administrative, investigative, and advocatory lines cannot be drawn as clearly in the real world as the Supreme Court has assumed. As one author phrased it, the existence of cases defying easy categorization reveals an inherent weakness in the functional approach. The approach implicitly assumes that every prosecutorial act fits, then you have to guess what the next word is, in one and only one category. Well, I must admit, I do find myself often shaking my head at the idea that, sometimes things are so simple and one size fits all when it comes to the legal system. Additionally, the functional test creates an incentive for prosecutors to claim that almost everything they do is a part of their function as advocates, thus ensuring absolute immunity for their acts. And of course, Ken Kratz tried to claim absolute immunity for his sexting scandal, which of course, very interestingly, is the case in which Rob Bellin acted as Ken's defense lawyer. Although I'm certainly not going to ask Rob Bellin about specifics of that case, because Rob's an ethical lawyer and is quite rightly going to point out that there is still, client confidentiality. You never stop being bound by that ethical rule. Anyway, it stated the bright line rule that a prosecutor neither is nor should consider himself to be an advocate before he has probable cause to have anyone arrested. Again, my mind goes back to Dawah Massey and his famous words in the Adnan Syed case. It's up to, he only needs, the bar is only set at 51% to make an arrest. It's up to the prosecutor to make up the other 49 and get the 100%, past the 100% bar for conviction. Anyway, but there is no useful indication of at what point probable cause will be had or who is to determine its existence. The functional test gives criminal defendants turned claimants bad incentives too, as Justice Kennedy noted in his dissent in Buckley. The court weakened its stance against the tort of malicious prosecution by introducing this bright line rule. In Imbler, the court had made it clear that it wanted to preserve the common law absolute immunity for prosecutors accused of malicious prosecution. Buckley's bright line rule ends up functioning as a pleading rule for claimants as long as they include at least some of the prosecutor's pre-probable cause conduct in their pleadings. Malicious prosecution claims are no longer easily dismissed. Instead, frivolous, malicious prosecution claims survive longer in the courts, disguised as a 1983 claim. Moreover, the distinction between advocatory acts and investigatory acts is not principled. It has been described as inherently elusive and highly questionable. Kennedy's dissent in Buckley points out that what the court labels investigation could easily be termed preparation for trial. Preparatory actions should be protected. They must be free of the distortive effects of potential liability. Otherwise, preparation is punished. A prosecutor who has properly and extensively investigated his case prior to a probable cause determination may find himself civilly liable for his decisions and actions, which have all taken place in the investigatory phase. Meanwhile, a prosecutor who does not open the case file until after the probable cause determination is protected because all of his decisions and actions are taking place in the advocatory phase. The court justifies its investigatory advocatory distinction by claiming that it would be unfair to offer police officers only qualified immunity for their investigative acts while protecting prosecutors with absolute immunity for their acts. However, that assumes that police and prosecutors are engaging in the same function while engaged in the same activity. This may not be the case. The way that police officers and prosecutors assess evidence is very different because they are driven by different goals. A police officer wants to establish probable cause to arrest a suspect. By contrast, a prosecutor who has to look at the long-term picture and assess how to turn evidence showing probable cause into a conviction beyond a reasonable doubt. Not too sure about that. I don't think they have any trouble making evidence go into a conviction, given the right judges, such as Willis and Fox. I don't think there was any danger of that. Moreover, in an ideal world, a prosecutor is not simply seeking another conviction. He is seeking to do justice. Well, yeah, that's very much the ideal world. For me, reading this stuff so far, I can't help thinking that, when it comes to prosecutorial misconduct, I think it's quite clear. I think there is a very bright line as to what is prosecutorial misconduct, and any kind of Brady violation is a prosecutorial misconduct. I don't see any reason why we've got these lawyers debating this to such extent. To me, it just seems, well, anyway, we'll hopefully ask Rob about that. Okay, the prosecutor has an ethical responsibility to seek out the truth of what happened in the case and should not seek a conviction against a defendant whom the prosecutor believes to be innocent. The distinction between advocatory acts and administrative acts is not principled either. As long as a prosecutor can somehow link an administrative act to the conduct of a trial, the utilization of legal knowledge or the exercise of related discretion, he or she is in the clear. This is not difficult to do. The Van der Kamp court states, it would indeed be striking to see the case where a criminal defendant brings a 1983 action against a prosecutor's office claiming that payroll administration led to the violation of his constitutional rights. By narrowly equating administrative functions with actions that will rarely, if ever, impact a defendant, Van der Kamp has effectively closed off claims of liability against prosecutors under a theory of qualified immunity for administrative acts. Just have a quick drink. Let's see, I'll get onto the black label later on. As I say, the functional test and the falsification of evidence. Beyond the problems noted above, perhaps the most egregious practical problem with the functional test is that the test makes it unclear whether prosecutors are liable under 1983 for falsifying evidence and presenting it at trial. It seems absurd that actions analogous to perjury should be allowed to go unpunished. Well, Kate, yeah, that's exactly what we feel as well. But the court's functional approach to prosecutorial immunity has led to some bizarre circular reasoning in this area, best exemplified by Justice Scalia's concurrence in Buckley. Falsified evidence cannot produce harm to a defendant until it is used. Well, yeah, okay. The false evidence made it into trial in Steve's case, but the false evidence was certainly being used in his press conference, long before it went to trial. So I'm not too sure about that. When prosecutors are preparing false evidence during their pre-trial, pre-probable cause investigatory function, they are protected only by qualified immunity, but the harm from the false evidence does not occur while it is being prepared. It occurs at trial when the evidence is used. Again, I take huge exception to that. We hear quite clearly Emily Matasic phoning Steve in the January of 2006, saying, Steve, why don't you just give up the game? You've got all this evidence against you. She honestly thought that she could say to him, look, you've got the key found in your room, the blood in the car, you've got the RAF found on the property, you were the last person to see her. She basically thought she could just phone up, present the facts to him, and he would just admit. So the harm from the false evidence does not occur while it is being prepared. I would say, I would disagree with that. Anyway, yet by the time the prosecutor is using the false evidence at trial, he is protected by absolute immunity. That just seems bizarre, doesn't it? The circuits have split on how to approach the issue. The Second, Eighth, and Ninth Circuits hold a prosecutor liable for producing false evidence under a qualified immunity theory. Well, this is interesting. Let's have a look. The Third and Seventh Circuit, I presume, circuits, have held that a prosecutor is absolutely immune from liability for presenting false evidence at trial. Because of a fairly arbitrary test created by the Supreme Court, a prosecutor can actually make up evidence presented at trial and not be held civilly liable for his actions. I know, it just beggars belief, doesn't it? The criminal defendant against whom the evidence is presented is left without recourse. Now, of course, we're on about civil liability. So we're talking about, that you can't take a civil suit against the prosecutor. Although, of course, that's exactly what did happen in Steve's 85 wrongful conviction. If he is wrongfully convicted on the basis of false evidence, he may sit in prison for years. If he has a dedicated legal team, perhaps he gets the conviction overturned and gets out of prison sooner. But typically, a defendant with a dedicated legal team is not the type of defendant who has to worry about false evidence being used against him without objection in the first place. Let's read that again. But typically, a defendant with a dedicated legal team is not the type of defendant who has to worry about false evidence being used against him without objection in the first place. Again, so I take it what she's saying is that when you get the right legal team, which could be years later, could be never, then you don't have to worry about it being used in the first place because that corruption will be discovered. I don't know. If and when he gets out, he may have no claim for civil damages for the prosecutors wrong. Ultimately, the functional test leads to some defendants convicted on the basis of false evidence, spending years in prisons for crimes that they did not commit. Well, you're certainly right there, Kate. The Supreme Court could resolve the circuit split in two ways. First, the court could rule that prosecutors are absolutely immune for presenting false evidence at trial. Again, that just seems completely bizarre to me. On the other hand, the court could grant prosecutors qualified immunity. I don't think they should be given any immunity for presenting false evidence at trial. What the dickens are they on about? For their actions at all stages of a prosecution, including trial, which would expose them to liability for falsifying evidence in relation to a defendant's constitutional rights. Considering how recently the court upheld the functional test in Connick, it is unlikely to resolve the circuit split over the falsification of evidence any time soon. B. What is a pattern? 36 years after Imler, the court has yet to articulate fully the scope of qualified immunity for prosecutors. The discussion of the Connick case at the appellate level demonstrates this. No one, including no justice on the court, seems to know exactly what constitutes a pattern of violations that shows deliberate indifference and leads to qualified immunity and liability under 1983. Once again, as I say, written before Making a Murderer came out. Connick v. Thompson evaluates multiple scenarios that might establish a pattern, and the majority of dissent appeared to disagree on whether liability exists for every single one. Unfortunately, the dissent itself is unclear on whether it is arguing for liability based on a single incident or a pattern. The dissent spreads a great deal of time and space laying out the facts that the jury had available to it, including other potential Brady violations that occurred in Thompson's case, and other cases in which Connick's office was held liable in civil suits for Brady violations. Yet it summarily concludes that the jury could have been holding Connick's office liable based on a single, I guess, Brady, single incident. Okay. The dissent never argues the obvious alternative, that the jury clearly had enough additional information to find a pattern from the multiple Brady violations occurring in Thompson's case. This is particularly frustrating because each time the majority dismisses a definition of a pattern, the dissent's factual evidence would seem to support such a definition, but the dissent stops short of actually calling anything a pattern. The Connick majority takes the view that the actions of multiple prosecutors in one case resulting in a single Brady violation, like in Thompson's case, does not constitute a pattern. What if multiple prosecutors violate Brady multiple times in one case? The majority swiftly dismisses in a footnote the idea that such behavior constitutes a pattern. Could multiple prosecutors violating Brady multiple times across multiple cases prove a pattern? The majority indicates that this too is insufficient to put a district attorney on notice of the need to train, at least in the case of the Orleans Parish District Attorney's Office. My God. Could multiple prosecutors violating multiple times across multiple cases prove a pattern? They can't even agree on that. Oh my God. Thompson argued that Connick's office had been reversed on appeal for Brady violations 4 times in the 10 years prior to his armed robbery prosecution. Thomas's opinion discounts this because the reversed decisions did not involve the hiding of scientific evidence like the blood type report in Thompson's case, but rather other forms of evidence. Thomas declines to state whether, if the other 4 cases had involved scientific evidence, he would have altered his opinion. What does clearly emerge from the analysis of both opinions is that what constitutes a pattern of constitutional violations is highly fact-bound. The application of this precedent regarding pattern will be difficult to apply to future cases. It is unclear that even the 5 justices of the majority are all in agreement as to what a pattern is. They just all happen to agree that Thompson's case did not prove it. Dear. Both the majority and dissent fail to address 2 additional situations that may reasonably constitute a pattern. First, one prosecutor could take actions across multiple cases, resulting in multiple Brady violations. Second, one prosecutor could take multiple actions in a single case that result in multiple Brady violations. Yes, you're right there, Kate. While there may be a pattern of violations in both instances, they stem from the actions of a single person rather than a group. That single prosecutor probably fits within Justice Scalia's definition of the miscreant prosecutor. What do you mean probably fits? Gee whiz. Oh, yeah, okay, so it's this judge's opinion, who may have some form of personal responsibility for his actions, but whose actions would not establish liability under 1983 for the office generally. Yes, I suppose it wasn't the whole of the Attorney's General Office that was being deposed. Sorry, of the whole of the Manitrock District Attorney's Office that was being pursued. It was Dennis Vogel and the sheriff, because there were people in the even in Dennis Vogel's office that came forward to Dennis and said, "Look, you need to look at this Gregory Allen. We don't think it's Stephen Avery." Okay. Neither side is particularly clear on what a single incident that gives rise to liability looks like either. It appears that a single incident could produce liability in 2 ways. First, there is the hypothetical in footnote 10 of Harris. Both sides agree that this is still good law. Second, the majority in Connick seems to say that something other than a pattern could give the district attorney a specific reason to know that additional training was necessary. The court may have added this language to leave the door open for prosecutorial liability, since its reasoning basically eviscerated Harris's single incident theory as applied to prosecutors. This is because assistant district attorneys will always have attended law school and passed the bar, so the district attorney will always be free to presume under Connick that they have adequate legal training to deal with Brady issues. So the specific reason that tips off the district attorney that more training is needed must be something other than inadequate training. The dissent argues that footnote 10 in Harris is directly applicable to Thompson's case because although young lawyers have been to law school and passed the bar, they do not necessarily know everything about the law that is required to do their jobs. We'll make this our last paragraph for today. Reconsidering the common law foundation of the rule. The practical effect of all of this confusion is that prosecutors have absolute immunity. Is that such a bad thing? I'm surprised you're even asking that question. After all, the court has repeatedly stated that in American common law, prosecutors always had absolute immunity. Well, no, if we look back to that investigation done in the late 1800s, 1870, they asked all 37 states, only 13 of which said that they supported absolute immunity, but they failed to take into account all the other states at the time who said, no, we don't want that. Imbler relied heavily on common law reasoning to establish the functional test. Section 1983 doesn't actually list any immunities at all, but the court has simply read the immunities available under the common law of 1871 when 1983 was passed. As I say, in 1871 was when this prosecutorial immunity was decided on the opinion of 13 of the 37 states at the time. While this approach is certainly artificial, it is something that the court has done in the past to reach a desired result. Unfortunately, in the prosecutorial immunity context, this approach makes no sense. In Imbler, after stating that prosecutors were absolutely immune under the common law of 1871, the court cites as evidence Griffith versus Slinkard, a case of malicious prosecution from 1896. Moreover, the court concedes that Griffiths was the first recorded case where absolute prosecutorial immunity is mentioned in American law. Justice Scalia's concurrence in Burns is more effective at describing the common law immunities than the majority in Imbler, but this argument still lacks persuasiveness as to why prosecutorial immunity should be read into Statute 1983. In American common law, there was absolute immunity for judges acting in their official judicial capacities. There was also absolute immunity for government servants acting in a quasi-judicial capacity. Finally, all statements made as part of a court proceeding were given absolute immunity from defamation suits. The Imbler court argued that absolute immunity should apply to prosecutors for the same policy reasons that absolute immunity is given to judges and jurors. In short, the immunity is designed to prevent the harassment of all parties in the prosecution and avoid any chilling effects that litigation might have. The court seemed to endorse the idea that prosecutors share absolute immunity protection under a quasi-judicial theory. However, this is not the same thing as a grant of absolute immunity at common law for prosecutors in their own right. Yet the court's jurisprudence has simplified the common law reasoning to this end. If the court were to acknowledge the tenuousness of its common law arguments, the justification for absolute immunity and the functional test weakens considerably. Even considering that the court's suppositions about absolute immunity in 1871 are correct, do we want modern prosecutors subjected to a rule created at a time when prosecution looked very different than it does today? First, with the rise of DNA and other scientific technology, there have been major advances in the collection of evidence since the common law rules regarding prosecutors were developed. Because there are so many more types of forensic evidence available to prosecutors today, there are also more opportunities for them to hide or tamper with that evidence. Additionally, prosecutors today are saddled with the enormous caseloads that simply did not exist when the common law was developing. There are more incentives now than ever before to cut corners in order to obtain convictions and speed up the trial process. Prosecutors' offices do not have the resources to handle the extraordinary number of cases. To maintain conviction rates, the temptation to conceal exculpatory evidence in violation of a defendant's constitutional rights is strong. However, despite the drastic differences between the early and modern American prosecution, there are compelling reasons for the court to institute an absolute immunity rule today. I suspect I couldn't disagree more with that idea. Anyway, we'll leave it there. We are at section number 4, so that was a whole whole section, part 3 dealt with. So we're at part 4, and that is alternative proposals. I'd like to thank you all for tuning in again today. Hi Mark, hi B Green, hi David, Jerome. Yep, nice to see you all here. As I say, if you're ever suffering from insomnia, you can always just play this video, and I'm sure that I will put you to sleep in less than no time. However, as I say, I do want to look very deeply at this. Well, exactly, Mark. How does the public benefit? Nobody benefits. So all it is, it's judges looking after their own kind. It's because they realize that they came from being lawyers to being prosecutors, becoming judges, and it's just looking after themselves. It's the worst form of nepotism I think I've ever seen. Anyway, we'll apart from judging at 1 or 2 accordion festivals that I've been involved in, not as a competitor, should I say, I've seen some very horrendous cases of wrongful judging. But I mean, that's not taking anybody's liberty away, you know. In a music competition, that's it's not a huge problem, not like we have here. Anyway, we'll catch you all again soon. I'm away to sort out some things with a violin and a guitar, and then I'll be getting stuck into the dude's whiskey. And if he's lucky, there might be some left for him tonight. Oh, hi, Millbilly. I was saying earlier at the beginning of the video, I have listened to most of your discussion. It was in the early hours of the morning for me when I woke up this morning, listened to it. It was an interesting debate. It's it's one of these things, as I said at the start, I don't think any of us can ever sort of say to somebody else, you know, I don't agree with your theory, you're completely wrong about this, because we just don't have the information available. Why? Because obviously they didn't investigate the case properly. Why? Because of prosecutorial wrongdoing. Ken Kratz made sure that they didn't investigate properly, and that's certainly my opinion. That we can't, discount anybody's theory. But isn't it interesting that in all of this, in all of the theories that come forward, you know, apart from the daft Gilter theories that support Ken Kratz's tale of Fantasyland, even the Gilters have difficulty explaining Ken Kratz's theory. Anyway, I better dash, and we'll see you all again soon. Take care, and catch you again some other time. Okay, as I say, watch out for some more bird videos if I have to do any more. And as I say, I do apologize. They were done for my wife so that she could entertain the kids at nursery. And if you're entertained by them, all well and good, because some of them are quite funny. Okay, catch you soon. Bye for now.